Hello, everyone, and welcome to Uncivil Law. For today's case, we have civil asset forfeiture. This is in the matter of $470,000. Robert Miller versus the state of Wyoming. In this case, the state of Wyoming took $470,000 from Mr. Miller under somewhat suspicious circumstances. But he wants his money back. The question is, does Wyoming have to give his money back? This is a decision from the Supreme Court of Wyoming determining who gets the $470,000. Will it be the state of Wyoming, or will it be Mr. Miller? Let's find out. On the evening of November the 18th, 2013, Wyoming maybe? Patrol trooper Brandon Dyson stopped Mr. Miller for speeding on Interstate 80 in Uintah County, Wyoming. Mr. Miller, the sole occupant of the car, told Trooper Dyson the car was a rental and he was traveling from Reno, Nevada to his home state of Illinois. That's a long way to travel by car on a rental, so that seems a little suspicious to me immediately. The agreement reflected that the car had been rented 2 days earlier in Fresno, California. Trooper Dyson invited Mr. Miller to sit in the passenger seat of his patrol car while Trooper Dyson wrote him a citation. Okay, just a little bit of a pro tip from me to you. All right, if the police ask you if you want to come to the patrol car, just say, no, I'm comfortable waiting here. Be polite about it. Don't be rude. But if they say, why, come back to my patrol car and sit in the car while I write your ticket, just say, no, I'm comfortable sitting here. Now, if they order you to get out and order you to come back, then you probably should do that. But if it's phrased as a request, then politely decline the request. And we're going to see another instance where, he made a request, which probably should have been denied. So if the police say, hey, why don't you just come wait in my patrol car while I write this ticket? I appreciate the officer. I appreciate the officer offer, appreciate the offer. But, I think I'll just wait here if it's okay with you. Something like that will be fine. Be very polite, beg off, because it's not going to end well. While Trooper Dyson completed the citation, they chatted about Mr. Miller's reason for visiting Fresno and his travel itinerary. See, this is why the police asked you to come. Because they want to keep talking to you. And so, they can do two things at the same time. Because, if they had just tried talking to you while you were sitting there, you could have made an argument that you're being held unlawfully because it is extending the scope of the stop. But if they're just talking to you while they're also issuing the citation, you can't make that argument. So this was very clever by the police, not so clever by Mr. Miller. Trooper Dyson noticed that what he considered to be signs of nervousness and deception. Another good reason not to talk to the police voluntarily. Trooper Dyson asked for and received permission from Mr. Miller to ask additional questions after completing the stop. Again, if the police are asking you, they have to ask you. If they're giving you an order, they're giving you an order. So it's like, if they're saying, can I search your car? Or do you mind if I search your car? Again, officer, I appreciate that, but I'm going to have to respectfully decline. I hope you understand. Something like that would be fine. If you know their name will be fine. Otherwise, officer, sir, always good to show respect to officers. They like it. So, officer, I appreciate that, you just want to do your job, but I'm going to have to respectfully decline. No need to get fancy about it. Just say no. And if they say, what's wrong? You have something to hide, and just say, officer, I'd prefer not to. There's no need to clarify. They're going to want you to clarify. So the officer's probably going to say something like, what's wrong? You're afraid of something? You want to hide something? And they're expecting you to justify yourself because, then they can tell the lie from the truth. So just don't do that. Just don't justify yourself. So if they pull me over and say, can I search your car? I'd say, officer, I appreciate you want to do that, and it's part of your job, but I'm going to have to respectfully say no, that you can't search my car. They said, well, what's the matter? You have something to hide? Say, officer, I just prefer to say no. And if they keep coming back to me, I'll just come up with different versions of, officer, I just really don't feel comfortable with that. Officer, I'm afraid I'm just going to have to respectfully insist that I not do that. I'm just going to keep coming back with general denials. I'm never going to justify, because if I justify, I get in trouble. These are pro tips to the wise. Again, if they're giving you an order, follow the order. If it's a request, deny it. Mr. Miller denied having anything illegal in the car and gave Trooper Dyson permission to search it. Don't do that. Don't give the police permission to search. It just makes life more difficult. When Trooper Dyson pulled back the carpet lining along the right side of the trunk, he discovered a manila envelope in the void behind the lining. The envelope contained rubber band bundles of currency, which is definitely how I transport currency when I have to transport currency, right? He saw at least one more manila envelope in the void behind the lining. He returned to his patrol car and read Mr. Miller his Miranda rights. Mr. Miller said he wanted to talk to a lawyer. The first smart thing he's done. He was read his Miranda rights and he says, I want to talk to a lawyer. Now, if you're really smart, he would have said, I don't want to talk to you before this point, but, we'll give him what credit we can. Trooper Dyson searched the car further and found 9 manila envelopes containing $470,000 in the rear quarter panels. This is a little bit suspicious. You're transporting $500,000 in cash, and you're transporting it in the void behind the carpeting in manila envelopes that are rubber banded together. I don't know a lot, but this strikes me as a little bit suspicious and outside the norm. Yeah. Mr. Miller also had $40 in his possession, which I don't know why we're mentioning that, but he had $40 in his wallet. Fine. Trooper Dyson learned from El Paso intelligence and an officer in California that Mr. Miller had ties to cases involving large quantities of LSD and LSD precursor in California. A Wyoming Division of Criminal Investigation Task Force officer contacted the Wyoming Attorney General's office later that night and received authorization to seize the currency under civil asset forfeiture. So at least the police had some information that this was linked to a crime. Normally we don't even get this much. Normally it's just like there's a lot of money. But here, they at least had information from other officers that he was tied to LSD production. So, he should have known his rights better and should have known better than to say, please search my car, because they found the money. And now he has to try to get the money back. Will he be successful? The state filed its complaint for forfeiture in rem, which is to say, against property, 270 days after the seizure. The complaint further alleges the currency was subject to forfeiture because it was used or intended for use in the delivery or receipt of controlled substance or otherwise used to facilitate a violation of Wyoming's Controlled Substances Act, which, all else being equal, seems somewhat plausible given what we know. Mr. Miller answered the complaint, generally denying the currency was subject to forfeiture. Among 15 affirmative defenses, he asserts that he had an innocent possessory and or ownership interest in the currency because it derived from legitimate activities. Would he like to tell us what those are? That'd be helpful. The complaint was barred by the statute of limitations, and the state had violated its statutory and federal and state constitutional obligations to initiate the action promptly. So he's arguing basically that I have a legitimate interest in it, and I also have a due process, and you waited too long to bring this complaint against my money. And so I want the money back because you waited too long. So let's find out. The state opposed Mr. Miller's motion, you don't say, they'd like their $500,000 very much, to dismiss on the grounds that he lacked standing to participate in the proceedings. The statute of limitations to file the forfeiture was 1 year under relevant law, and the initiation proceedings of 270 days did not violate his due process rights because Barker rights weighed in his favor. The court converted Mr. Miller's motion to dismiss to a motion for summary judgment and denied it because Mr. Miller had not demonstrated the non-existence of a material fact nor his entitlement to a judgment as a matter of law on the claimed violation of his due process. Mr. Miller unsuccessfully moved for reconsideration. After several more rulings adverse to Mr. Miller, the district court held a bench trial and forfeited the currency to the state, and this appeal filed. So the district court was having none of this. They had a bench trial, which, remind you, is against the money. So it's under a preponderance of the evidence standard. So more likely than not, 51%. So they found it, the money had done wrong. And they seized it. And he's appealing to the Supreme Court of Wyoming. Well, let's see what the Supreme Court of Wyoming has to say about this. Civil asset forfeiture under Wyoming state law is appropriate only with respect to certain types of property, which the legislature has deemed subject to forfeiture. The state sought to forfeit the $470,000 under the law, which identified the following as a subject of forfeiture. Any property furnished in exchange for a controlled substance in violation of this act, including any proceeds, assets, or other property of any kind traceable to the exchange, and any monies, securities, or other negotiable instruments used to facilitate a violation of the act. The legislature also imposed certain procedural restrictions on the state's access to the forfeiture. The law outlines circumstances in which state law enforcement officer may seize the property with and without process. And I assume here they mean without prior process, not without all process, without prior process. All right. Property subject to forfeiture under the Act may be seized by any law enforcement officer of the state under processes issued by any district court or district court commissioner having jurisdiction. So it can be seized if you have permission from a court. Seizure without process may be made if the seizure is incident to arrest or search under a search warrant or inspection under an administrative inspection warrant. So it was seized pursuant to arrest. The property subject to seizure has been the subject of prior judgment in favor of the state in any criminal injunction or forfeiture proceeding based on the act. So if we already had a right to it, it was already our property. So we're not really seizing it because it was already ours. That's fair enough, I suppose. The board or commissioner has probable cause to believe the property was or is intended to be used in violation of law. There is no dispute that the state seized the currency from Mr. Miller without the process required by law. Subsection C requires the state to institute forfeiture proceedings promptly, stating, in the event of a seizure pursuant to subsection B, proceedings under subsection D shall be instituted promptly. From the beginning, the state has incorrectly insisted the statute allows the state 1 year from the date of seizures to institute forfeiture proceedings. That statute of limitation applies to civil actions other than recovery of real property. So that wouldn't apply here because that statute of limitations is for recovery other than real property. Yeah, so that, The 1 year statute of limitations did not apply to Mr. Miller's case because the forfeiture statute prescribed a different, albeit exacting limitation. It required the state to institute proceedings promptly. So although this one section of law seems to apply, there's one dealing specifically with civil asset forfeiture. And generally speaking, the specific overcomes the general. So if you have two different laws that read on the same thing, as a general proposition, the specific one governs if there's a conflict. And so there's a rule dealing with property in general. There's also one dealing with civil asset forfeiture. And so it's like, well, the more specific governs this specific situation. That isn't necessarily the case everywhere. Your mileage may vary under your specific state law, but as a general statement of law, that's a fair summary. We have recognized that promptly is not an exact term. You don't say. A civil forfeiture proceeding is quasi-criminal. Accordingly, civil forfeiture proceedings implicates a person's due process rights. The pertinent provision of the 5th and 14th Amendments to the United States Constitution essentially provide, no person shall be deprived of life, liberty, or property without due process of law. Procedural due process is satisfied if a person is afforded adequate notice and an opportunity to be heard at a meaningful time and in a meaningful manner. So depending on the situation, this can be before the fact or after the fact. This is after the fact. So the question is, was he being given due process after the fact? The United States Supreme Court held in its seminal case $8,850, and we're definitely going to have to cover that on a future Supreme Court React. We'll cover the case of $8,850. The four-factor test developed in Barker to evaluate a defendant's speedy trial right on the 6th Amendment provides a relevant framework for determining whether delay was reasonable. Factors are the length of delay, the reason for the delay, the assertion of the right, and the prejudice to the claimant. The overarching factor in applying the Barker test is the length of the delay. Here, the 270-day delay between the seizure of $470,000 from Mr. Miller without process on November the 18th and initiation of proceedings was a significant lapse of time weighing heavily against the state. Wait, it weighs heavily against the state? You mean there's a chance he might get his money back? Let's read on. There was never any pending criminal proceedings against Mr. Miller with respect to the currency seizure, but the courts have extended the $8,850 discussion of criminal proceedings to criminal investigations. At some point, however, the government's interest in completing an investigation is outweighed by the interest of the claimant in his property. Here, the state's evaluation of whether to initiate forfeiture proceedings and the ongoing criminal investigations could justify some of the delay. We are troubled, however, by the state's reliance on criminal investigations to justify a 7-month delay from November 2013 to June 2014, when the record is clear the state's delay was underpinned from the beginning by the state's erroneous belief that had 1 year to file the action. The state made a mistake as to law. The state misread its own law. You gotta be happy, guys. Spoiler alert, he's gonna get his money back. So it's not every day the drug dealer gets his $500,000 back. So you gotta be happy. The state sought to justify the second period of delay on the basis it was waiting for Mr. Miller to accept or reject a settlement offer. Circumstances dictate whether effort to negotiate settlement before forfeiture is an acceptable reason for delay. The problem with the state's reliance on its settlement offer to justify the additional 45 days of delay is that it, too, was underpinned by the state's belief it had 1 year to initiate proceedings. Not so much. The state extended a settlement offer to Mr. Miller more than 7 months after the seizure, and only after it determined the criminal investigations were completed. At that point, while continuing to believe there was no urgency to proceed, the state could not reasonably justify further delay by offering a settlement. Isaac, you got the right answer. That's very good, Isaac. Very, very good, Isaac. I like that. How big a cut will the lawyer want? Yes. That's good, Isaac. I applaud you. Very good. Very good. Very good. This brings us to the question of how much weight to assign the second factor. In the speedy trial context, which is instructive here because the same four-factor test applies, we distinguish between unnecessary delay, which is a deliberate attempt to hamper the defense, and delay resulting from more neutral reasons such as negligence. Which is this? We believe, as other courts have recognized, that broader prejudice analysis is warranted. The claimant may show prejudice by showing the state deprived him of ownership right to the property. Mr. Miller suffers a similar prejudice. The seizure deprives him of his ownership of a substantial sum of money, including his right to use, enjoy, and invest it. Though the currency cannot be characterized as a wasting asset, Mr. Miller's due process rights were further prejudiced because the state seized currency without process that was available under the 2013 statute, increasing the risk that the seizure was an arbitrary encroachment on the property rights. The remaining two factors carry less weight, however, because Mr. Miller objected to the delay and expressed his due process concerns. The third factor also weighs in his favor. As to the fourth factor, Mr. Miller suffered some prejudice under a fair rating of $8,850, and again, I just love case names that are money. It just rolls off the tongue. Because the state's lengthy delay resulted in a large part from erroneous reliance on a one-year statute of limitations, the prejudice Mr. Miller did suffer was enough to tip the scale into his favor. The state failed to promptly institute the forfeiture proceedings in violation of Wyoming law and Mr. Miller's right to due process under the United States Constitution. We therefore reverse and remand for dismissal with prejudice. The state must return the currency to Mr. Miller. Hey, buddy. Baby, I got your money, don't you worry. Said, hey, baby, I got your money. Hey, hey, baby, I got your money, don't you worry. Said, hey, baby, I got your money. Well, dollar bill, y'all. That is the end of the case of $470,000 in the issue of Mr. Miller versus the state of Wyoming. In this case, the state of Wyoming found Mr. Miller with $470,000 tucked away in his trunk in manila envelopes, and they took it because of drug dealing ties. Now, I don't know whether or not Mr. Miller is a drug dealer or anything, but I will note that having money rubber banded in manila envelopes stuck in your trunk lining is a little bit atypical and does suggest some sort of nefarious deed of some variety, whatever. But whatever he was up to, Mr. Miller is going to get his money back. Civil asset forfeiture actually failed. Amazing. He's going to get his money back because the state of Wyoming failed to give him due process. They thought they had a year. They did not have a year. And so this potential alleged former drug dealer gets his $500,000 back. And that's the end of this story. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.